are the heirs at law in intestate succession? Imagine someone passes away without leaving a will. Who gets to inherit their belongings? That's where heirs at law come into play. They are the people who are legally entitled to inherit under state laws when no will exists. These laws are set up to make sure assets go to close family members first. The first in line is usually the surviving spouse. If the person was married, the spouse often inherits most or all of the estate, especially if the property is community property or jointly owned. Next are the children, whether they are biological or legally adopted. If there is no surviving spouse, the children typically share the estate equally. If a child has already died, their children, the decedent's grandchildren, may inherit their share through a process called representation. When there are no children or spouse, the estate goes to the parents of the deceased. If the parents are not alive, then brothers and sisters of the decedent become the heirs. Their children, the nieces and nephews, can also inherit if the siblings are not around. If no close relatives are found, the estate might go further out to grandparents, aunts, uncles, or cousins. If no relatives can be located after a certain period, the estate will usually go to the state through a process called escheat. Knowing who the heirs at law are is very important in estate planning and probate. It helps clarify what happens when someone dies without a will. It also guides estate administrators and lawyers in distributing assets properly. Keep in mind that laws about heirs at law can differ from state to state, so the exact order and shares might change depending on where you live. Overall, the rules prioritize close family members first, starting with the spouse and children, then moving outward to more distant relatives. This system makes sure that assets stay within the family when no estate plan is in place.